Hello, I'm Jim Turk, and this is the ninth in the Center for Free Expression's series on Taming Big Tech, exploring the alternatives. I want to begin by acknowledging that the land on which I'm speaking to you today is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nation, Inuit, and Métis. I also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit and the Williams Treaties with multiple Mississaugas and Chippewa bands. Our conversation today will explore the question of how Canada can lead in privacy reform globally. Our discussion is co-sponsored by the Edmonton Public Library, the Milton Public Library, the Thunder Bay Public Library, the Toronto Public Library, and the Vancouver Public Library. And I'd like to thank our co-sponsors for their support and involvement. Our featured guest today is Elizabeth Denham. Elizabeth is currently an international consultant on data and technology at Baker McKenzie, one of the world's largest law firms with offices in 46 countries. Elizabeth has a really impressive history in this area. For the last 5 years, she was the Information Commissioner for the United Kingdom. During her tenure in the UK, she also chaired the Global Privacy Assembly, which brings together more than 130 data protection authorities around the world, the premier global forum for data protection. Prior to that, she was the Information and Privacy Commissioner for British Columbia, and before that, Assistant Privacy Commissioner of Canada, and before that, Director of Privacy of the Private Sector for the Office of the Information and Privacy Commissioner of Alberta. So she certainly has her Canadian credentials as well as her British ones. She's also widely recognized as a leader in enabling responsible data use by government and the commercial sector, and for implementing the EU General Data Protection Regulation, the GDPR, into UK law. We're really honored to have you with us today, Elizabeth. Thank you for joining us.
Thank you, Jim.
Elizabeth is going to be in conversation with Andrew Clement. Andrew has been the moderator of all of the sessions in our series on Taming Big Tech. He's a Professor Emeritus in the Faculty of Information at the University of Toronto, where he coordinates the Information Policy Research Program and co-founded the Identity, Privacy, and Security Institute. With a PhD in computer science, Andrew has longstanding research and teaching interests in the social implementation of information communication technologies and participatory design. Welcome, Andrew.
Hello.
The format for today's conversation is Andrew and Elizabeth are going to be talking for the next 45 to 55 minutes, having a conversation with each other on key issues. And then we're going to turn to you, the audience, for your questions and participation. If you could look at the bottom of your screen, move your cursor down to the bottom of your screen, you'll see a Q&A button. The chat function in this is disabled, but the Q&A function works. So if you'd like to ask a question of Elizabeth or Andrew or both, at any time during the conversation, just go down and click on the Q&A button and write out your question. And when we come to that part of this event, Andrew will turn to Ange Holmes, who's the coordinator of the Center for Free Expression, to ask her to share the first question that a member of the audience has put forward. And we'll go through each of the questions in turn over the course of the remaining part of the event. So please think of questions as they come up and feel free to ask questions. This is a rare opportunity where we have such distinguished participants in our conversation, and I hope you'll take advantage of raising questions or concerns or issues that you would like to hear them address. So that's it. Over to you, Andrew and Elizabeth.
Well, thank you, Jim, and welcome, Liz, and welcome all of you out in Zoom land in the final installment of this season's Taming Big Tech series. I'm reaching you from my home on the West Coast in the unceded territory and ancestral homelands of the Saanich Nation and other Salish-speaking peoples. I live near Victoria, which memorializes the imperial monarch in whose name this territory was stolen to establish what to this day we call British Columbia. We're able to have this conversation thanks to a remarkable digital network whose physical features belie its popular characterization as a placeless cloud. In North America, at least, the fiber optic cables carrying the signals between us still largely follow the railways that colonial agents pushed through the lands of numerous First Peoples. The data switching centers are mainly located in big featureless buildings in the core of our largest cities, right near where these railways built their major stations well over a century ago. This high degree of physical centralization of critical network infrastructure has greatly facilitated our signal intelligence agencies, the NSA in the US and Communications Security Establishment, CSE, in Canada, to intercept all our internet communication and selectively monitor it for perceived threats, all in the name of national security. Liz, I am delighted to have this opportunity to explore with you the question of whether and how Canada can lead in privacy reform globally. As a former Assistant Privacy Commissioner for Canada, then BC's Information and Privacy Commissioner, and from 2016 until October of this past year, you've been the UK's Information Commissioner, so you've really seen a lot here. You bring a wealth of experience and a unique perspective on what Canada might consider as it wrestles with updating its private sector privacy legislation at both the federal and the provincial levels. Your 5-year tenure as Information Commissioner came at a particularly interesting and even a pivotal time, with major challenges you probably didn't anticipate when you took on the job. In your first year, Brexit happened. A referendum of 2017 declared that Britain was just by a very small margin going to leave the EU, which finally happened in January of 2020. The next year brought on the EU's General Data Protection Regulation, and months before the Gdpr came into force in March 2018, the Cambridge Analytica and Facebook scandal broke, marking an inflection point in public attitudes against the social media giant and other big tech platforms whose business models rely heavily on monetizing vast quantities of personal information. So you were there for that and had to deal with it. Could you start us off by giving some highlights of what this period was like for you and your staff? And this will set the stage for going deeper into the issues that animate this Taming Big Tech series. So over to you, Liz.
Thanks, Andrew, for reminding me of those years and all the challenges that they brought. When I accepted the role as UK Information Commissioner, it was just before the referendum. Everybody said the referendum was going to go one way and it went the other way. Many of my colleagues said, well, don't worry, that you'll still be part of the EDPB, even outside of the EU, and that didn't happen. But I took the job because I thought I would have the quiet little task of bringing in the GDPR. And what I didn't realize was that these 5 years, the past five and a half years in the UK, have been a time of extreme political and social turmoil. I saw 3 prime ministers, 5 secretaries of state that were responsible for the legislation. We had the pandemic, which all of us know that there were many data protection and privacy issues around that. And I had a staff of 800 that were all of a sudden working from home. So we had all of these challenges. But I have to say, because the way you described it, I thought maybe I should be looking at counseling for PTSD or something like that. But no, it was if I had to do it all over again, if knowing what I know now, I still would have accepted the job, because it was very challenging from a personal development perspective, massive. And don't forget, I had to walk into a different culture, a different business culture, a different political culture, and some would say a completely different language in understanding how the UK operates.
Yeah, well, kudos to you. You would still do that. I mean, it would obviously have been very exciting, and there are probably moments when you might have wondered why you had left Victoria. But let's go into the Cambridge Analytica and the Facebook scandal. As I indicated, that at least I think that a popular imagination was really something that sort of almost broke a dam. And to mangle a metaphor, it's the tip of the iceberg in terms of revealing how our personal data gets monetized by these large platforms. And in this particular case, it was taking very fine-grained personal information from a survey that was done surreptitiously and then used for micro-targeting and profiling for election campaigns, including being used in the Leave campaign of Brexit. Trump's election also allegedly was used Cambridge Analytica data, and around the world there were many countries where elections were fought using this, and so you really had a hot mess on your lap, and you did some remarkable things with it.
Well, and thank you for reminding me of that black swan case again, Andrew. But I mean, Cambridge Analytica is a small British company, so I have to start there, and fully within the jurisdiction of the ICO. And reading about some of the revelations that the whistleblower Christopher Wiley made, the work of Carol Cadwallader of the Observer, this Cambridge Analytica and Facebook, I really think for that case, that's when data protection came out of the shadows. So I think before Facebook and Cambridge Analytica, people knew that there were theoretical issues around behavioral targeting. They knew that those technologies were being used to influence us to buy trainers and holidays and cars. But I think the fact that there was evidence that these same technologies were now being used to influence, micro-target, send people into filter bubbles, impact our democracy, that was a big deal for people. And I think even when people didn't know the details of what Facebook, what the personality quizzes, what happened there, what Alexander Kogan, who was the academic, did with that data, and how that data from Facebook, 87 million people, people's profiles and data, who their friends were, that was mashed up with a lot of other data in the political ecosystem. And that includes political analytics companies, political parties, data brokers. So you know what? This was a holy shit moment for the ICO, because we realized that we had to not just look at the data that was shared between Facebook and Cambridge Analytica, but also the whole ecosystem, Andrew. So we were looking at 35 different organizations. And, at the end of the day, we prosecuted Cambridge Analytica. They had already gone into administration. The ICO had their kit. So we took their servers. We had the equivalent of 700 terabytes of data to crunch through, and never had a data protection authority seize data that was in the cloud, applied forensic data analysis. This was a highly complex case. And the last thing, because I could spend this whole 45 minutes talking about Facebook but let me say this. For the very first time, I was able to say, and I was widely quoted for this, that data crimes are real crimes. And so when we were able to prosecute these companies, when we were able to fine Facebook, even though we had to use our pre-GDPR fines, which maxed out at £500,000, it made a big splash. And the ICO had to work with the FBI, with the Federal Trade Commission, with the Securities and Exchange Commission, and data protection authorities around the world. So it was a really big deal. But from a public perspective, it was so important because I think people, even around the dinner tables around the world, said, wait a second here. Why am I getting this political ad? How is my data being shared and used surreptitiously and opaquely around the world? So I really think it was a big deal, that case.
Yes, indeed. And one of the things that particularly impressed me about the approach that you and your staff took was, as you mentioned, an ecosystem approach, that you weren't just going after the two sort of visible culprits, but you were trying to investigate the I use the word the trafficking in personal information, and sort of dig down into the information brokers and the ways in which information is sloshing around out of our visibility, but that comes up and can bite us. And you've said that, and I'm quoting from a talk that you gave at the Oxford Internet Institute last year. And what we need now is 21st century thinking for a 21st century problem. And that kind of speech often lends itself to being a bit of a platitude. But in this case, I think there's a tremendous substance to it that people are not actually fully aware of, or the way I would put it is that, and I wonder whether you might agree with this, that the rise of the social media platforms, big tech, the rise of a surveillance data model that Zuboff in particular, but others have described, the ad tech industry with this sort of massive of various kinds of actors that are seizing our information and packaging it, repackaging it, and selling on. That is sort of the bulk of the iceberg that we have very little visibility into, and that, at least for the private sector, represents, I guess, the sort of the biggest new 21st century problem. And would you agree with that kind of? I mean, there's a lot of problems around privacy, but would you agree with that kind of analysis, that it has brought something new, that and that our
The platforms have brought something new, you mean?
Yes,
the platforms and the digital marketplaces.
Yes, and the sort of surveillance business model, which I think Zuboff overstates the novelty of Google inventing that in 2001, but has really flourished and has produced huge wealth and power for these organizations. That's relatively unprecedented, and that doesn't fit neatly with the fair information practice regimes as they have been established by regulation and legislation up to this point.
No, and I do agree. Our legislation, so Canada's legislation right now, PIPEDA and the private sector privacy laws in the provinces, I would say that they're still first generation privacy laws. And I think what Canada's doing is looking at obviously reforming and updating them through Bill C-11. We can talk about whether we think that's enough, but they're trying to move into, I think, what GDPR has set a standard as being second generation data protection laws, and we can talk about that. But I think, even when GDPR came into force, it was already outdated. And where we need to go is another leap and bound into what I can see as third generation data protection and privacy laws. And maybe later in the conversation, we can talk about what I think that is. But right now, Canada is really looking to step into second generation, and they are leaving, I think the government's leaving out some of the key tools to be able to deal with the surveillance infrastructure and business models that we see.
Yes, I think that's a really important point. But before we'll get into those kinds of questions, but in a moment, but I'd like to have you talk a bit more about how in the UK you dealt with that. I mean, in addition to, and maybe coming out of this investigation of Cambridge Analytica and Facebook, you also were part of working with your other regulators in different sectors, in competition and finance and so on. And this has been something that's come up in this series before, particularly with my conversation with Conrad van Finkenstein, who was the head of the CRTC, the Canadian telecom regulator, and then also with around he was a head of the Competition Bureau. So those are two areas that are outside the privacy realm, but you were dealing with their UK equivalents, and you saw that you had an issue that was bigger than any of you, and you didn't want to step on each other's toes, and you wanted to work together, and that we haven't seen yet in Canada, and I think that's particularly significant.
I think it's innovative, the approach that the UK is taking with all of the digital regulators. And I mean, in a sense, the question that policymakers were asking, and we've seen this in other places around the world, is, wait a second here, with these internet technologies and the role of data, which is the asset of the 21st century, do we need a digital regulator? Do we need one big internet regulator? Mm-hmm. And I think that the Competition and Markets Authority, the ICO, my former office, the equivalent of the CRTC, which is called Ofcom, that's the communications regulator, and also the financial services regulator, all got together and said, okay, our institutional boundaries don't work so very well when it comes to the digital economy. And what can we do? And instead of cheerleading for yet another regulator, and instead of parking tanks on each other's lawns, I think we all realized that we had a place to play in the digital economy and regulating the digital economy. And rather than fight over who's first to the scene when there is a breach or a contravention of the law, we formed, amongst the 4 regulators, a cooperation forum, and it's a real thing. It's not a tea and sandwich club. It has real staff and a CEO, and the staff are seconded from the 4 regulators. And what do? We work on joint positions. There may be a cooperation and an investigation by the antitrust regulator and the ICO, because that's happened. When it comes to video sharing platforms, that's the responsibility of Ofcom. And yet, with the new age-appropriate design code, which is an ICO code, there's real overlaps there. So, I mean, why are we doing this? I think it's working better because we are realizing that the policy infrastructure that we saw that was built in an offline world doesn't work for the digital economy. So we need something new. And rather than wait for the lawmakers to create something, the regulators got together. Now, government was a little bit uncomfortable with that at the beginning, but I think they, because it's all the work that the Digital Regulators Cooperation Forum is transparent. There's a business plan, we report to Parliament. I think government is looking at this as world leading in terms of collaboration. And you know what? Canada can do this too. Yeah. Because Canada's a middling country, and the regulators are all in one city. So you could see the kind of collaboration. And rather than wait until policymakers fine tune how all of these different policy areas should work together, I think there's some thinking that could be done and some innovation by the regulators themselves.
I think that's a really important point. And it occurs to me that one of the commonalities that you might have found across these various regulators, and a point that you have made, is the need for much greater transparency about the the data flows and the relations between the various actors within that ecosystem we referred to. And that would help inform competition bureaus in Canada, as well as just the privacy commissioners. So how do you see bringing transparency and presumably its companion accountability to that ecosystem, and where can there be this continued collaboration? I mean, is that something that's shared amongst them, that they are all operating to some degree in the dark, and could do with more tools that would bring to light?
Yes, I think in particular, the work that the Ofcom regulator is going to have to do around online harms. So the work to regulate content on the big platforms requires transparency and accountability. It requires a systems approach, looking at how these companies are policing their own systems for harms, putting a duty of care on platforms and large marketplaces to be transparent, to publish how they're policing their sites, how many takedowns, instead of having somebody actually regulate content, which is an impossible task, you set the standards for systems and processes to make it happen. And then you put an independent, well-resourced, strong regulator behind it. So I think transparency and accountability are the two key areas where I'm afraid our laws have fallen down. I'm afraid our enforcement has fallen down. We were all too late to the game when it came to big platforms, now the size of nation states. But I like to think that there's been so much work done around the world that we're actually getting to grip with this now. But transparency and accountability, Andrew, very important in content online harms, very important in competition and how the business models are working to make sure that you've got a competitive environment. Transparency and accountability, that's a no-brainer when it comes to data protection and privacy. We haven't always done a great job of pushing those provisions. And I'll end my soapbox at this point in our conversation by saying that I think the most important upgrade in the GDPR is enforceable accountability. And that's the most meaningful change. And when I look at Bill C-11, I think, where's accountability? It was invented in Canada. It needs to be enforceable here.
Yeah, yes. Well, I hope, thank you for that. I hope you'll get on your soapbox again before we finish our conversation. But I think that's a really important point. One of the differences between Canadian data protection and UK data protection is that in the UK, you have a data registry, which is longstanding. It's a bit lame in some respects in terms of the registration fees are maximum of a couple £1,000, even for a giant. But it seems to me that it might play an important role. You understand that you deregistered Facebook or Cambridge Analytica anyway. Clearview AI, which you did a similar investigation to the one that was done here in Canada. But also the registry could provide a form of transparency if everybody's required, every organization is required to register, and then have a bit more information than you currently have in your registry about, who you're dealing with or what kind of sector you're in, and how much information or what kinds of information you're collecting. If you had that kind of registry as a requirement, that would seems to me to provide some important transparency. And also the fees, even though they're relatively small, you say that they, underwrote much of your budget for a staff, if you said, of 800, which is large. Do you think Canada could do well to look at that? Many areas of consumer protection have a requirement for registration. Yeah, and in Toronto, hot dog vendors have to register and they have long forms to fill out. They have to pay fees, yet these giants can take our information and do whatever without even having to say boo to anybody. So can you say a bit more about the registry?
I won't agree that it's completely lame. I will say that the fees are low. It's £35 for a small business to register as a data, because they're processing personal data.
Yeah.
So the registry in the UK is a first step. It could be a lot more fulsome, and it could get us towards the kind of transparency that we're talking about here, Andrew. So it's a bare bones registry. In other words, if you are a small, medium, or large size company or government, so it's not just private sector, it's local government, it's national governments, you have to, and charities, you have to register with the ICO. Now, that's supposed to be a way to educate all of those bodies as to what their obligations are. So, I mean, it does help, because we would send a package to a small business that's operating an HR consultancy, here are your obligations under the law. But we don't have enough information in the registry to be able to use it as a true transparency tool.
Yeah.
And I think that's what you're saying.
Yeah, that's why I say it's a bit lame in terms of.
It's a bit lame. But having said that, 80% of the funds, because there's 5 million small businesses in the UK, 80% of the funds of the budget of the ICO are paid for by the registration fee. That means it doesn't come out of government coffers. The rest of the funds come from government because they need to fund the freedom of information work that the office is responsible for.
Right.
But I also wanted to say that one of the issues that just before I left, finished my term, I said to the government, there should be an ability for the ICO to retain some of the fines that have been administered. And it's because, if you think about the inequality of arms, Andrew, between some of the big companies that the government regulator has to litigate against, that just, we just don't have the funds to be able to take on these giants. And yet anything we do collect goes into general revenue, not to pay our litigation fees. And it seems like a no-brainer, but I wasn't able to convince Treasury of that while I was the ICO.
Yeah, important points. Let's move on to the GDPR. It's come up several times. That's the General Data Protection Regulation, which the European Commission, have we got that right, has established to replace the former directive from the mid-1995, I believe. And you've referred to it as a second generation that is already out of date, but it's in many ways world leading at this point. They supplemented with some other legislation like the Digital Services and Digital Markets Acts and so on. They recognize that it's but could you talk a bit more about the GDPR as you experienced it and what you had to deal with in terms of getting to some degree of compliance?
So, first of all, one of the major differences, just for those of you who are steeped in the Canadian laws, the GDPR applies broadly across all sectors. Okay, so government sector, the charitable sector, the private sector. It basically, if you're processing personal information, unless it's personal, unless you're an individual, you're covered.
And that includes political parties, which is a big issue in Canada. Yes.
So that includes political parties. So it's a comprehensive piece of legislation, which is one of its strengths. The other one of its strengths is that I feel like when the EU drafted the GDPR, they took the best hits and the best provisions from around the world and included them in the GDPR. So, privacy by design is a Canadian concept. Well, it's enforceable in the GDPR. Accountability, one would argue, a Canadian concept. It's in the law. So privacy by design and default, privacy impact assessments, codes and certification, which we've seen in the UK prior to the GDPR, and we've seen them in Australia, for example. Codes and certifications are in the law. Artificial intelligence, so the right of an individual to challenge decisions made by machines. That's an important provision in the GDPR. It doesn't go far enough. We can talk about that. But I really think that the GDPR is the best hits of the privacy laws around the world. And it's not a European civil law experiment or creation. I think it's so far beyond that, but it's not a perfect law. It is quite prescriptive in certain areas. And that's one of the things I think the UK wants to strip out of its version of the GDPR. Mm-hmm. But it's true that the GDPR has inspired law reform and has inspired new laws around the world. So now hundreds of millions of more people have privacy protection because the EU decided to create this omnibus law that has extraterritorial reach. Mm-hmm.
One of its features is that it enshrines privacy as a fundamental human right, in accordance with the UN Declaration on Human Rights. That's an issue in Canada. What about in the UK? Or does that would you see that as did you try to encourage the UK government to accept that as well?
No, it's fundamental right in the UK.
So that's not controversial.
Well, is it controversial?
Well, okay, but it's established in a way.
It's established in law.
Yeah.
It's established in law. I would say that the interpretation of the law and the enforcement of the law in the UK is more pragmatic and more selective, I suppose, than you would see in the EU. So, I mean, you can have the same law in the books, but it can be interpreted and applied differently, can't it? Depending on who's looking at that. So it's really important, the cultural context and the business context that you work in, even the arguably the personality of the regulator and how innovative they want to be. I think that's also part of the picture.
Yeah. Another issue that's come up in sort of in, say, EU data protection versus the rest of the world, in particular the US, is what was called the Safe Harbor Agreement that allowed the transfer of European personal information to jurisdictions where they didn't have equivalent law, but that companies could sign on to this agreement. And that was challenged twice by a remarkable young man, Max Schrems, and it went all the way up to the European Court of Justice. And it was thrown out, and they developed a new one, a Privacy Shield. They threw that out. And that was on the basis of what Edward Snowden revealed about the surveillance by the National Security Agency and the Five Eyes more generally, particularly their PRISM program, which get access to the major tech companies. Now, the UK and Canada are part of that Five Eyes alliance. The UK is no mean slouch when it comes to surveillance through the GCHQ. Was that an issue that you had to deal with? Because if the Europeans, I'd say, are rightly concerned about moving data to the US or other places where that was subject to that kind of surveillance, where they had no rights, they lost their rights compared to Americans. Was that something that came up in the UK?
Well, absolutely. So the UK has been granted 2 adequacy agreements with the EU. So the UK has been judged essentially equivalent for the protection of EU citizens and residents' data. So the UK is a safe place because its law and its regulation and the enforcement and the whole legal framework has been determined to be essentially equivalent. So the EU has, both for law enforcement and for commercial operations, been deemed adequate. There was some question about whether the EU would be, whether the EU would determine that the UK's system, especially when it comes to intelligence services and surveillance, was protective of EU citizens. They said yes, but it's a time, it's a time, was it 3 or no, it's a 4-year adequacy agreement. And the EU will continue to monitor the UK. But I have to say that as the Information Commissioner, I was very much involved in drafting deep explanations for the EU on how our laws and our system worked, including the oversight of intelligence services. So the UK has made some significant changes in how its intelligence services and bulk collection of data are managed. And without going into all the details, privacy commissioners are very much expert advisors to their governments on how the law actually works on the ground. Now, the big conversation that's going on right now is the transatlantic data flows and what's going to happen with Privacy Shield 2. Now, we know that Privacy Shield 2, which is an agreement between the EU and the US, has been agreed to at a high level, so in principle, and now the officials are hammering out the details. And this agreement will replace Privacy Shield 1. Hopefully it'll be more robust, Andrew. And the two big issues are the oversight of the collection of data, personal data, by intelligence services. What's the oversight? And also what form of law is actually going to bring in those changes? An executive order is what I think is on the offing.
Well,
we
we're
get
getting
to talk about this for 30 minutes.
Yes,
too.
yes, of course. And we're now getting into the sort of the international data protection realm, and you, and at the end of your term as the Information Commissioner, were the chair of the Global Privacy Assembly, this 130 privacy commissioners around the world. And I guess I have two questions for you here. Is why is international harmonization of data protection regimes important? I mean, and I guess of how important is that, because it's far from easy to accomplish. And then you've made a I don't know what you call it, whether it's a trial balloon, but
A call to arms.
a call to arms, right? So you've called for a Bretton Woods for data, not for privacy, but it's modeled on the Bretton Woods agreement that established our international financial system after the Second World War. And in many ways, that's worked really well. In other ways, people will complain a lot about the IMF and the World Bank and so on. But could you just sort of sketch for us what you mean by this Bretton Woods for data, what you think it can accomplish? And
let's start with your first question, which is, why is international harmonization important? And it's important because our discussions about transborder data flows and cross-border data are sucking all the oxygen out of the room. There's so much advocacy group time, government time and resources, policymakers trying to sort out that problem, that I feel like we've taken our eye off the ball of what some of the real harms are. Children's privacy online, the epidemic of fraud online. There's so many things that we could be working on other than just getting cross-border data flows right. And I think the problem with the system is that privacy laws are always going to be national. They're always based in culture and in the legal framework of the country. That said, there's so much similarity. And I learned that in spades when I was chair of the Global Privacy Assembly for 3 years. There was a lot of mapping of principles that we did between all the DPAs, data protection authorities. And we have so much more in common than what separates us. And it seems to me, Andrew, that with political will, we could find a harmonized standard that at least provided interoperability between the countries. We have to solve this problem of transborder data flows.
Mhm.
And that's when I said we need a Bretton Woods for data, it's because what doesn't work is all of the countries crossing their arms and standing in judgment of the way another country deals with data privacy. It just doesn't work. The EU is very keen on fundamental rights. I can understand that, but there are other ways to protect data. And so what Bretton Woods implies is let's get all the stakeholders together, policymakers, academics, good thinkers, regulators, businesses, and maybe we need to start again with fresh thinking that really takes account of the digital technologies and the business models that we're dealing with, because data knows no borders. And therefore, we need global data protection. And that's really what I'm calling for. And you know, I don't have a platform anymore. I'm not the information commissioner. But you know, I talk to a lot of policymakers and leaders around the world, and it seems to me that there are some international initiatives, some discussions where policymakers are starting to talk about this. The G7, the OECD, which is looking at standards, governance standards for the use of data by intelligence services. The Trade and Technology Council, which is an EU-US construct. And I also think, you know, my adopted country, I think the UK could play an outsized role in this because they're outside of the EU and yet they've got the strong law. The UK is respected around the world. It has a strong technology sector, and it could play such a role, but it needs to stop putting a stick in EU's eye and, you know, really, I think, grow up in the way. See, this is me unplugged now.
Yes, you can say things perhaps that you only thought before. It strikes me that well, you've mentioned a number of different approaches. Two of the ones that I'm aware of is what's known as Convention 108, which is EU's attempt, Council of Europe's attempt to spread a kind of GDPR-like regime that other countries can agree to. And I don't know all of the differences between them, but my understanding is that it doesn't have quite as much of the rigor and requirements that the GDPR would imply.
It's true. It's more principle based, and there's an updated Convention 108 called Convention 108 Plus.
Yeah.
Canada is not a signatory to it, by the way.
Yeah.
But
and this has been going on since 1981.
It's 40 years old.
And Canada has not agreed to that.
No, but
it's
interesting that many South American countries have signed on to Convention 108. So and it's not an EU convention, it's a European convention.
Yeah.
And so I do think that's important, but it's not enforceable. So what we really need is we need a standard that is interoperable and enforceable.
Mm-hmm.
And that's why I'm calling for Bretton Woods. And it feels like Convention 108 doesn't quite do it. It could be a building block though.
Yeah. Another one, and this comes out of our earlier conversation, is APEX, which is Asia Pacific Economic Cooperation Agreement, I guess. Their Global Cross-Border Privacy Rules Forum. It's quite a mouthful, which is led by the US and does have Canada signed on to, and I think UK is thinking about signing on. And that strikes me as being almost a counter to the European approach. And I guess there's a lot of questions you could could ask about here. But in terms of addressing the challenge of big tech that we discussed earlier, which of those two do you think is most likely to be effective? And I understand that the 108 is not enforceable at the moment, but there may be ways in which it could become enforceable without undermining its principles, and such as human right, privacy as a human right, and accountability and transparency and things like that. That I don't know the APEC one at all. So
the good news about the APEC CBPR, cross-border privacy rule, is that it is a certification scheme backed by, so you have third-party certifiers backed by enforcers, like the Privacy Commissioner of Canada would be ultimately the enforcer for Canada in the CBPR. The good news about CBPR is that there was an announcement 2 weeks ago to pull CBPR out of APEC and to go global. And that I think will be really interesting. And I'm optimistic about that. The more countries that agree to the cross-border privacy rules, even if it runs alongside in parallel to the EU adequacy arrangements, it could still improve the way data flows around the world. But it needed to be pulled out of APEC, I think, and going global.
Do you think it will help rein in the excesses of the big tech, or are they happy with it and they'll think that it will?
No, I mean, it's an enforcement scheme. I mean, there's a few things about big tech besides cross-border transfers. I mean, it's really, the question is, how do we make sure that people's fundamental rights, that people and society are respected in the way that data is used? So getting outside of just the safety of transfers around the world. I said earlier that data knows no borders, data is global. And I think ultimately we do need that global enforcement, Andrew. You can just see how if 30 countries and regulators around the world are all investigating Cambridge Analytica and Facebook, that doesn't make any sense. You've seen a multiple of commissioners and regulators looking at Clearview AI. They're all finding roughly the same outstanding issues.
No surprise.
And yet, I mean, we do need to work together for better enforcement. It's not like we have unlimited resources. We do need to collaborate more with my counterparts, my former counterparts around the world, to get enforcement right. And you need changes in law for that.
So let's now sort of wrap up, or at least as part of the discussion, by looking at specifically of what Canada can do. It's in the midst, as you know, of trying to update and modernize its legislation provincially and federally. There's talk of a made in Ontario privacy regulation, but you're talking about global harmonization, and these seem to be a bit at odds. What do you think are the main lessons that Canada can learn as it goes through this exercise, based on your experience? And we've talked about a number of these things.
So what do they, okay, so I'm going to go for it. We've already talked about inclusion of political parties, I think, in the scope of the law. I mean, there was so much concern amongst policymakers and advocacy groups and others around political parties and their potential to use data in ways that contravene the law, except they're not subject to it. So I do think extending the law to cover federal political parties in C11 is important. I think also businesses and business leaders may have actually looked at that issue and asked the question, why are we covered by it, but politicians and political parties are not? So I don't think that's gone unnoticed.
Yes.
And then I would get to, there are some modern tools that I would say are second generation tools that aren't in the current draft. And so again, I was looking for privacy impact assessments when they would be mandatory. And I think taking some of the language from the GDPR is important, mandatory, as well as when there's high risk and a company can't mitigate those risks, that the privacy commissioner should have a look at that PIA. So I find PIAs are really important. I talked about codes and certification. And I think one of the strengths in both GDPR and also in the UK tradition of privacy laws is having statutory codes that are enforceable. Okay, these are not guidelines.
Yeah.
You've seen the age appropriate design code that's come out of the UK. And that is a statutory code that is 15 standards for companies that are likely to be accessed by children, for online companies. They have to comply with 15 standards.
Mm-hmm.
And those standards are things like privacy by default and design. So location tracking turned off, children's profiles turned off, behavioral advertising turned off by default. So these 15 standards are enforceable. And I think if C11 had the ability for the commissioner or another body to create codes, it's going to make the legislation last a lot longer, because you could see other codes being drafted for artificial intelligence in the healthcare sector, or whatever the issue is. You can develop a code that deals with context, Andrew, or particular technologies. What else would I say is on my list? Obviously, power. You know, the Privacy Commissioner of Canada is an ombudsman.
Yeah.
This does not work when data is the asset of the 21st century. Where are the administrative monetary penalties and the enforcement powers? You know, this is, and I'm not saying fines are everything, because sometimes fines, even the billions of dollars, can be rounding errors to these big companies. But fines are generally dissuasive for bad practice, and they also get the attention of boardrooms. And the last one, I mean, there are many other things I could say that are important upgrades to the law in Canada, but we talked about cross-border data flows. That's a big deal right now, and we don't have the Bretton Woods for harmonized data flow, do we? So in the meantime, I was looking for something in the law to be able to put some obligations on companies and organizations to assess the safeguards that are in place, legal and otherwise, to the receiving organization. Does that make sense?
Mm-hmm. It seems pretty basic. But
what are the methods? You know, Quebec, I think Quebec's new legislation has some specifics around this that I would hope that the government takes a look at.
C11 was silent on these matters, unfortunately.
And the rest of them all worked tough about them.
Mm-hmm. What about the, I guess, a data registry, as we've talked about?
Yeah, I think a data registry is a great idea. I would be more ambitious about it than the UK's registry.
Yeah.
I think you know, Daniel Terry and some of his staff were really interested in the funding, how the ICO was funded. They were interested in the funding issue. But it's a tradition in the UK that regulators, especially those that are overseeing private companies, are funded. It's sort of like a polluter pays kind of system. And the more data you're processing, the higher your fee.
Right, that seems to be basic. Enshrining privacy as a human right, that seems to be.
I think it's a constitutional question.
Yeah.
I'm not a lawyer, so you can help me answer that one.
Yeah.
I think it's problematic, though, isn't it?
Yeah. And what about trying to meet GDPR adequacy in any Canadian legislation? You've argued for harmonization. That's an obvious one. current PIPEDA, the Personal Information Protection Electronic Documents Act, has long been considered adequate. It seems to me that we're at risk of losing that adequacy, so that trade with Europe is going to be affected. Should Canada try to keep adequacy for GDPR?
I think there are some real benefits, both in the reputation of Canada around the world, but also for businesses that, you know, don't have to put other measures in place like contractual arrangements, standard contractual clauses. They don't have to put other measures in place because they can rely on the adequacy finding. Until we have a new way forward where there's an international standard, I think adequacy is worth retaining.
Mm-hmm.
And I think Canada is going to be reassessed, just like all of the other jurisdictions that have existing adequacy arrangements with the EU. Canada is due to be reassessed and needs a modernization. I don't think anyone's arguing that we don't need to modernize our laws.
No, everybody agrees on that, I think. So far, it looks more like that Canada needs to do a lot of catching up with developments elsewhere. I mean, the title of this session I provocatively called, and you went along with it, of how can Canada lead? Do you think there's anything that Canada could do if it had the ambition and the courage to step out and lead here? And this will be the sort of final question, because I know that there's some people want to ask questions themselves.
So I looked at the title and I thought, what am I going to say to this? And I've talked about how Canada needs to update at least to get to second generation laws and be looking to the future. I also think that, first of all, Canada is widely respected around the world. It's a middling economy. It has strong relationships with Europe, as well as looking to the Asia Pacific, neighbor to the south. So there's a lot that Canada can do to sort of be influential in the world. I know that privacy commissioners, you know, going back to Jennifer Stoddard and Danielle Therrien, are respected in the field. So I think Canada has that going for it. But I wish they would be a bit more ambitious right now to look at how the regulators could work together in a way that is modeled somewhat on what the UK is doing. Because I think as we debate some of these other pieces of legislation like online harms, content regulation, I think we could actually do more and be more ambitious. So I would like to see Canada do that, but you know, and I'm happy to be home, I should tell you that.
Yes.
I forgot to tell you that at the beginning.
Yeah, welcome back. You've been, I understand that you go back and forth still, but you're in Victoria at the moment, I understand.
I'm in Victoria, and I'm working for a children's charity that really advocates for children's rights online. And the really exciting thing right now, Andrew, is that the age-appropriate design code from the US has been copied and pasted into a bill before the California legislature. So that's going to be really interesting to see if the children's code makes its way across the pond.
Yeah, well, I'm sure you're looking forward to that, because that's a real achievement. That would be so we're going over our usual time. I see there's some questions. I usually ask what are some resources, but we can at this point, but that you might recommend to us, but we'll just post those afterwards if that's okay.
Mm-hmm.
If you have any questions, and we've given you, I think, a lot to think about, maybe a lot to digest before you can come up with some questions, but please use the Q&A button at the bottom of the screen. Move your cursor down there and get your questions into the queue, and we'll feed them to us. So I think we're ready, Ange, for our first question. So please go ahead.
Okay, yeah, as Andrew said, please do use the Q&A button if you have a question. The first question from an attendee, they ask, in dealing with online harm, should the major platforms, which have effectively become the public square for public discourse, be permitted to impose their own standards for permissible expression that restricts forms of legal expression?
Okay,
Okay.
that's a really key question. It's an interesting one from a privacy point of view, but we've already stepped outside that realm here and having to think about, content.
So, I mean, it's going to be a noisy debate in Canada. And we already see, I think, from the Globe and Mail in the last couple of days, you've seen the editorials about how to regulate online harms. In Europe and the UK, the approach is, I think I mentioned this earlier, to define, get companies to define the systems and processes that they have in place to protect their online users. And what does that mean? I don't think that you can have a regulator who is going to be the Department of Speech. I think what needs to happen is a positive obligation in law that companies have a duty of care towards their users. So that's going to look different, isn't it, for a Disney site where kids are there versus, the Twitter sphere. So you look at Twitter or you look at Facebook, they have different, I suppose, standards. But I think what's important is that they're transparent about those standards. They're transparent about the policies. They're transparent and accountable for the decisions that they make. So I'm not trying to duck the question. I'm saying that we can't regulate individual pieces of content. Instead, we can regulate whether or not the systems and processes are in place to protect people, and then require the big platforms to report on how they're doing that. And codes of conduct are probably really important here too.
And what agencies or regulators do you think would then be responsible for checking on that?
Well, in the UK, it's Ofcom, which is the telecommunications regulator, because they have some experience in regulating broadcasting content. So you can see that. That said, it's still a completely different world in regulating online content. And it will be, the online harms bill is before the UK Parliament right now, and it is noisy. And freedom of expression is a really key issue, but no right is absolute. And the other thing I would say, it's a great question, is that it's much easier to regulate content that is already illegal rather than regulate content which may be offensive to some but is not illegal. So, it's easy enough about children, trading in human trafficking and pornographic images of children and hate speech. All of these things are already illegal. But I think the really difficult part is regulating what may be offensive, but it's not been deemed illegal.
Yes, well, we could talk quite a bit more about that, and the CFE speaker series has delved into that in many occasions. So I urge our listeners viewers to check that out too, because it's I think that's a really interesting response, but there's obviously so much more that could be said about that, and people have weighed in on that. So Ange, could we have the next question?
Yeah, the next question from an attendee. They say, I heard Canada has now allowed public institutions to store data on non-Canadian servers. Is this true, and is this bad?
Yeah, so data sovereignty question and jurisdictions, at least.
I mean, I think generally speaking, you're seeing more and more laws around the world that are requiring data localization. And that really runs counter that really runs counter to this idea of data flows with trust. So data sovereignty and data localization, I think, are not good things. It's not reflective of the way our economies work. So your question assumes that there is a ban on Canadian data being stored on servers outside of Canada, and there isn't such a ban. The province of British Columbia had a provision for data localization in the public sector, but that was altered and changed in the latest iteration of law reform, right? If that's what
Really?
we're
Okay.
talking about.
Yeah. Well, I'll take a different view quite from you, Liz, here around the virtues or the evils of data localization. I mean, you say that it runs counter to the free data flows with trust. And I think we can agree that where trust is justified, in other words, you've got real regimes of protection across different jurisdictions, that there's a good argument that data should be allowed to flow freely. The problem is that we do not have trust across multiple jurisdictions. And so what do you do in the meantime? Do you say, well, let's hope that that will happen in the future? Or do we say, at least until we have a real basis of trust, then to protect the data of citizens, Canadians in this case, it's important that we keep that data within Canadian jurisdiction under Canadian laws and constitution. And I've made a bit of a deal of our data routinely going to the United States, even for domestic communication purposes. Even for me to communicate with a federal government website in Ottawa, my research shows that that data often goes via the US, where it loses all of those protections. So I wouldn't have trouble with our data flowing across the Atlantic to Europe if those protections were robust, but going to the United States, I don't think we can trust that. And hence, that's why I think it makes sense to have a provisional data localization, national sovereignty, data sovereignty provisions in the meantime, while we work for a more cosmopolitan world where we can be sovereign, but also engage in mutually, respectful treaties between nation states to protect the data as if it was our own. When we have that regime, I think then the argument for data localization goes away. But in the meantime, let's not pretend that our data is actually being protected when it goes outside our borders. I think data, you say data doesn't know borders, but data is always somewhere, and wherever that is physically determines the jurisdiction, and also it determines other things like whether it can be intercepted, who has access to it, what they can do with it, and so on. So I'm not quite prepared to go with you yet. If your Bretton Woods proposal works, then maybe.
So yes, I mean, the reality is, though, that even data localization provisions in India or South Africa, some of these jurisdictions are putting data localization in place. And, the reality is that data is still flowing. So, I mean, we can talk technically about the realities of it, but the question assumed that there was data localization now in our law. And I think there's policies at the federal government level to keep data in Canada rather than contract it out, let's say, across the border. I don't think that's a ban on data flowing to the US, but we may have to take another look at this. Otherwise, we could keep talking for 15 minutes.
Yes. And I see there's a number of more questions, and we should get to as many as we can. So Ange, next question, please.
Yeah, the next question is from Conrad. Conrad says, if I understood you correctly, the Digital Regulators Cooperation Forum was formed without a legislative base. I think it is a great innovative step that should have been taken long ago. However, there are restrictions regarding confidentiality of data and info that are built into the constituting statute of each participating agency. How are you overcoming these restrictions to get meaningful cooperation?
Yes, and that Conrad, as you might figure out, was a
I know.
former guest in the series,
a
so
great
he
question.
knows a lot about where he speaks. So
Yeah.
go for it.
So you're absolutely right, Conrad, that the DRCF, the Digital Regulators Cooperation Forum, was created by the regulators without a statutory base. I think the desire and the ambition was just to get something going. And it has really grown into a body that has staff and a chief executive officer. But ultimately, it's still those agencies, those 4 agencies that I mentioned, that are running the shop. I think it's an interim step before getting to something more formal. And you're absolutely right that what we need in law is more ability to share information that's related to an investigation, as well as, I shouldn't say we, I should say them, because I'm not one of them anymore, information sharing provisions in law, as well as perhaps duties to take account of the other policy areas. And you'll see that that's one of the provisions in the online safety bill, is a duty to have regard to privacy for Ofcom. So those recommendations were made by the DRCF to legislators. So I think it's a matter of time before those changes are put in place. Such a great question.
Yeah, it is. Ange, next question.
Yeah, the next question from an attendee. As part of updating privacy legislation in Canada, updating our definition of publicly available will have important implications for national security agencies, all of whom are increasingly turning to big data analytics as a means to generate intelligence. What are your views on this issue and on the data set sharing that is taking place between Canadian agencies and allied agencies?
Wow, great question, and we could
question.
take another couple of hours, so go for it.
Okay, so I mean, what you're saying is what kind of guardrails or restraints should be put on intelligence services for using publicly available information? Is that the question? Is that the right take on the question, Andrew?
Sorry, would you like me to read it again, or?
Yeah, maybe that would be a good idea.
Behind it.
Yeah.
Okay, as part of the updating privacy legislation in Canada, updating our definition of publicly available will have important implications for national security agencies, all of whom are increasingly turning to big data analytics as a means to generate intelligence. What are your views on this issue and on the data set sharing that is taking place between Canadian agencies and allied agencies?
Yeah, and the person who asked that question confirmed that, yes, this is what he's getting at.
Okay, so if we're talking about, intelligence services, national security agencies need to do their job. They have an important job to do to keep us safe. And the question is always necessity and proportionality in the collection and use of the data and the oversight of how those intelligence services are using data. So I think what Canada needs to do, and what some of the other partners have done in the Five Eyes, UK and New Zealand in particular, is they have strengthened the oversight regime of intelligence services. They've strengthened it by putting separate tribunals in place for judges to make determinations on bulk collections of data. So we've seen changes in the oversight, and I think that's what we need. Because as you say, analytics, I think what you imply in your question is analytics are getting so much deeper and are able to actually drill down and create intelligence from all of our digital data trails that we leave everywhere we go. But, I think the question is proportionality and oversight. Transparency to to a parliamentary committee or to a tribunal or a set of judges is a good thing.
Canada, until very recently, did not have any kind of oversight body for their agencies, and now it's got the National Security Intelligence Review Agency, which has begun to do that work, but it's still very young. It's already found that one of the agencies was not being as forthcoming as they had expected in terms of what they were doing. So there's some progress to be made there, but certainly there's a step in the right direction already. Andrew, can we have time for another question, perhaps two?
Okay, the next question is from Garth, and Garth asks, I've always felt that if by law I own the data that is, after all, an extension of my identity into online space, regardless of who collects and aggregates it into a model of my behavior, I would gain more capacity myself to have my rights respected. Is that possible?
Basic question. That there's a question of whether you actually own your own data in a sort of legal sense, but I think the sentiment there is pretty clear.
I think the sentiment is about agency and not about data ownership, because I mean, obviously when your physician creates a record of your visit, you don't own the record, but you have access to the record. So let's just set aside the legal concept and go to the agency concept. Yes, in the best of all possible worlds, you should be able to assert agency for your data, which is yourself, online. And that means you should be able to challenge how that data is collected, used, and disclosed. The problem is that data sharing and business models have become so complex that it's becoming more and more difficult for individuals to be able to assert their rights. And I think that's why we need strong regulators that are pulling back the curtain and actually looking at what's happening to data. I think public interest research is really important. Academics and civil society should bring issues and complaints to the commissioner's offices, and individuals can still make a big difference. They can take their cases to privacy commissioners and information commissioners, and I would encourage you to do it. I don't know, Andrew, if you want to add anything to that, but I mean, that's the point of privacy legislation, that you can assert your agency.
Yes, I agree with that. The problem, and you've pointed to it already, is that the complexity of your data flows, I mean, they far exceed our ability to understand them. I mean, that's partly by design, and that they're kept obscure, and that the current law requires us to complain if we think our data has been misused. But who's got the time in their life, and how can you actually tell there? So I think we, as you were said at the end, we need data protection experts, regulators who have the authority, some of the things you've talked about earlier in our conversations, like to be able to go in and seize a server, if necessary, of no-knock warrants, of being able to really assert an authority on behalf of us as data citizens and consumers, to be able to do that. And we're a long way from that at the moment. And I think we're losing the battle, and that the commissioners should step up. And we also need other organizations, because they can't do it all, to act with us and on our behalf, if we're going to exert agency. Huh?
I want to underscore the importance of having advocacy groups and public interest researchers and academics to bring issues forward, because data protection commissioners, privacy commissioners can't do it all. But individual complaints are also a source of intelligence for data protection agencies.
Mm-hmm. Yes, I think we have time for one more quick question, or the question can be quick, but we also have to be quick about the answer. But Ange, go ahead.
The next question is from David, and David says, compared to Australia, Canada has a Bill of Rights. How does the bill relate to privacy, and does it actually benefit an individual more than a corporation?
You want to go for that?
I don't I haven't brought those two together. I mean, we have a Bill of Rights, but we haven't declared that privacy is a fundamental right.
Right, yeah.
Is that what you would say, Andrew?
That seems to me the essence of the question and the problem is that we talk about rights in privacy regulation and so on, but it's always put in a position of balancing commercial interest of using that, and so we're into that kind of balancing game. There's nothing that I know of in Canada that has real force that says you have to give primacy to the human rights, and that the commercial operators need to defer to that, while we also, of course, need to enable them to get on with their legitimate business. But that I don't think that our Bill of Rights, and I'm no lawyer, actually gives that to us. So thanks for that question and all the other great ones. I think this has been a really stimulating session, and I guess I want to thank you, Liz, for what has been a really wonderful conversation. I mean, you both know a lot, and you also incredibly articulate about what you know, and that's helpful for us in thinking about these things. So thank you. Tomorrow, Ange will post a recording of this session to the podcast section of the Center for Free Expression website, as well as on its YouTube channel. And you'll also find some links, we might not get them up there tomorrow, but to the materials, the acts and legislation and groups that we've mentioned in our conversation. So that would be, I hope, helpful for you following up. So if you found this session valuable and interesting, please tell others about it, and they can join in and share this. If you have any feedback about what you liked or didn't like about this session or previous ones, this is the end of the second season, whether you've got suggestions for future topics or guests or resources we should know about, please email us. The Center for Free Expression's email is on its website, and mine is andrew.clement@utoronto.ca. So we look forward to hearing from you and getting some feedback. I hope you found this session as rewarding as I have. We're taking a break over the summer, but I expect we'll be back in the fall. That depends a little bit on what reactions we have, but I'm certainly thinking about it and hope we will do that. So I hope you'll join me again when we start up once more, and you can sign up for notifications on the CFE website. So again, thank you very much, Liz. Good luck in your future ventures.
Delighted.
Particularly around your children's advocacy. I think that's a huge area that's with great potential, and who better to help with that than you. Thanks, Ange, for setting this up, and also for Luke behind the scenes making this possible. And then thank you all for attending and asking interesting questions. Back to you, Jim.
Well, I want to join you, Andrew, in thanking Elizabeth for being our guest today. It was really stimulating, and there was a lot, I think, for our audience to follow up on. And as Andrew mentioned, we'll be posting resources on our website along with the video of this session. So you can turn to that if you want to dig in a little more deeply in issues that came up today. And I want to thank Andrew once again for his fine job in moderating this whole series. And I want to thank the audience for joining us today. If you want to see the other conversations in the series, this is the 9th of them. They're all available on the Center for Free Expression website, which is cfe.ryerson.ca. You also see our many other past programs on related issues. So feel free to go there and also look at our blog and our resource materials on many aspects of expressive freedom that weave together in dealing with both issues of privacy and regulation of the internet. So thank you for joining us today. And we look forward to having you join us at future events. Again, all the details about our future events are at cfe.ryerson.ca. Goodbye.
Bye-bye. Thanks again, Liz.
Hi, thank you.